Okay, so a happy 4th of July in advance to all who is on today's webinar. Welcome. Welcome to the Rutgers-Newark Small Business Development Center's After Lunch webinar. This is actually one of 2 webinars being held today, so we're glad that you're here with us for the next 90 minutes. For those of you who are not familiar with the SBDC stands for Small Business Development Center, and we are a resource center for the United States Small Business Administration. The objective of our organization is to provide one-on-one business consulting to individuals who are trying to start a business, or if you're already an established business and you need help in any area that can be marketing, government procurement, exporting, access to capital. We have consultants with expertise in various areas that will be assigned to you should you request help, and help mentor you or walk you through any issues that you are facing, or if you're trying to grow your business. They will consult with you. This is provided to you at no cost. It's paid for by your tax dollars. The SBDC network in New Jersey, it's called the NJSBDC, and we have 12 centers across New Jersey, each center responsible for 1 or more counties. Our jurisdiction here at Rutgers-Newark is Essex County. So if you live in the Essex County area or your business resides in Essex County, you will come to us for your one-on-one counseling. We also provide a lot of webinars and training workshops and events, and you are free to attend these across the state. It doesn't matter the county in which you live or your business is, but it's just the one-on-one business counseling. You have to seek out the center in your county. To do so, you just simply need to visit our website at www.rnsbdc.com. RN for Rutgers-Newark, SBDC.com. If you're outside of Essex County, you can still use this website and submit your request for counseling. We'll forward your request to the appropriate SBDC office, and they will follow up with you within 24 to 48 hours. Today's webinar is going to be discussing intellectual property, the basics. A lot of us here, due to the pandemic, we're starting businesses, we are trying to pivot and change, change focus and try to see if we can drum up business. We're creating new ideas, starting new ventures, and a lot of those may need to be protected. And so today's webinar is going to cover the basics of that. Please note that if you need more information, you need help in, submitting for a trademark or copyright, please fill out that request for counseling form. We have various counselors that can help you through that. So I'm not going to take up too much more of your time, just a little bit more housekeeping. If you have any questions that you need answers throughout the presentation, please use the chat box. It's located to the bottom or the right of your screen. I'm not sure, depending on what you're viewing this on. Just post your question in the chat box. You can also use the Q&A section on here, and we'll try our best to answer your question. At the end of today's webinar, you will be emailed the slide presentation as well as a recording. The recordings usually go up, and it takes about 24 to 48 hours for us to kind of upload it. We usually upload it to YouTube and send that link out so that you can review today's webinar over and over again, and it stays there, I guess, for the next 90 days. So again, if you have any questions, feel free to use the chat box. And without further ado, I'll turn today over to Wendy Oliveros, your presenter for today. Wendy?
Yes, thank you, Priscilla. Welcome, everyone. It's great to be speaking with all of you today, and thank you for joining us this afternoon. A very special thanks goes out to New Jersey, the New Jersey SBDC Center at Rutgers-Newark for partnering with us today. My name is Wendy Oliveris, and I am the creative founder and CEO at Chess Global Alliance, LLC. We provide small business consulting and training services for companies in the corporate, education, nonprofit, and government sectors. And it is with great pleasure that I will be sharing information and tips on intellectual property basics for the small business owner and inventor. But before I actually begin that presentation, I would like to take this moment to state a brief disclaimer as follows. This presentation and webinar was prepared by me, Wendy Oliveris, for informational purposes only and does not constitute legal advice or establish an attorney-client relationship. All participants on this webinar should discuss their own particular situations with their attorneys before taking or refraining from taking any action. So thank you for that. Okay, so let's begin. As a small business owner, entrepreneur, or inventor, there are many things to consider in your efforts to start and build a business, including handling your day-to-day operations, maintaining compliance with business and employment laws, budgeting, marketing, and advertising. Yet, many small business owners fail to protect their creative ideas, whether it is a product or a service. As a matter of fact, one top mistake most business owners make is that they don't take out the time to conduct proper research in their startup endeavors. And as a result, they end up being sued for copying someone else's idea. And trust me, that could be a very costly mistake. This webinar is organized so that you can expect the following, because my goal is to help you demystify the basics of IP protection, including identifying what patents are, trade secrets, copyrights, and trademarks. This way, you can learn to make more informed decisions in your future. Now remember, knowing the types of protections which are best for you and your company is half the battle won. I will then identify general issues relative to the patents and trademarks and trade secrets, copyrights, and trademarks, since they can expose your company to major liability and unanticipated legal costs in the future. And then at the end of the presentation, I will also provide a great list of helpful resources, which you can refer back to at any other time. And then I just added something very recently to this presentation is I would like to also segue into the uspto.gov website on screen so that I can show you how to navigate through, their different compartments, for example, or categories, patents and the trademarks and copyrights, just so that you have a good sense of, what to do when you're ready to start doing that research. And then there will be a brief Q&A session at the end of the presentation as well. So feel free to type questions in either the chat box, and I'll do my best to answer them at the end. So let's proceed. When we talk about intellectual property, we're basically talking about brand names, books, songs, inventions, and secret formulas. Legally protecting these assets is what intellectual property law is basically all about. The intellectual property rights for patents cover new and useful inventions, such as mechanical patents, which is considered a tool for cutting or shaping metal, electrical patents, considered circuits for connecting memory to a computer bus, chemical patents, considered a formulation for inks to make them water soluble, biotech patents, considered immunological assays, design patents, which could be the shape of a chair, and finally, plant patents, which could be considered an asexual reproduction of distinct and new variety of a plant. The intellectual property rights for trade secrets, however, cover secret information that has economic value. For example, customer information, business plans, proposals, databases, and manufacturing processes are all considered trade secrets. The intellectual property rights for copyrights cover unique expressions of ideas, including but not limited to software codes, website content, musical compositions, audio recordings, movies, books, articles, diagrams, and even photographs. Lastly, the intellectual property rights for trademarks cover a product or service, such as brand names, logos, and domain names. With regard to patents and protecting your inventions, think of Thomas Edison as an example. In 1879, Thomas Edison ran electricity through an incandescent filament, and he invented the modern light bulb, which he obtained a patent for. Remember, patents protect inventions. A patent, therefore, is a property right given by our federal government through the United States Patent and Trademark Office to an inventor. With a patent, the inventor has the right to prohibit others from making, using, offering for sale, or selling the invention. And in return for that exclusive right, the inventor must disclose the invention to the public so that others can learn from it. Now, there are several types of patents to consider, which I will briefly describe as follows. A method patent is a way of treating materials to produce a result. An example of a method patent would be software processes, algorithms, as well as the method for making plastics. A machine patent contains a mechanically, electrically, or electronically operated device for performing a task. In patent law, the term means the same thing as mechanism, device, engine, or apparatus. Examples of machine patents would be plasma monitors and network routers. Composition of matter type of patents contain chemical and metallurgical compositions. This type may include certain combinations of ingredients and new compounds. Examples of composition of matter patents would be chemicals and pharmaceuticals. Manufacture patents, however, relate to articles or objects that are man-made from raw materials. Note, it is considered a catch-all category which covers products other than machines and compositions of matter. Now, some examples of articles of manufacture are ceramics, cast metal articles, hammers, crowbars, chairs, shovels, gloves, shoes, envelopes, and even mouse pads. Lastly, with regard to other categories of patents, examples may include ornamental designs of functional items and asexually produced plants. Examples of ornamental designs are jewelry, furniture, and beverage containers. Think of the Coca-Cola bottle shape as an example. Another example of an asexually produced plant patent would include buds and cutting of roses. So you have a great patent idea, but it still must fall within the requirements for patentability. In other words, is your patent invention a novelty, utility, or non-obvious patent? For instance, novelty patents must be new and not already known by the general public or those skilled in the field of invention. Utility patents, however, must have a useful purpose and actually work. They must not be frivolous or immoral. And lastly, non-obviousness patents must not be obvious to a person with ordinary skill in the field of the invention at the time the invention was made. Now consider when you begin the process of creating your patent invention. It's highly recommended that you would do the following. Make sure to document all steps taken to come up with the invention. So there will be a record to support the validity of the invention if you were challenged by another inventor in court. Do not let other people know about your invention before you file a patent application, because you may lose the right to patent the invention. Register the patent invention as soon as possible for protection. Please note that registration is not required for trademarks, copyrights, and trade secrets, however. Well, we'll cover that later on in more detail. Finally, the term of the patent is typically 20 years, but keep in mind the actual term may vary depending upon the country issuing the patent, which we're going to segue into international patents. Aside from understanding United States basic patent rights and requirements, it is equally important to familiarize yourselves about international applications and foreign patents in the event you're thinking of going global. Since patent rights are territorial, they need registration in each territory at issue for protection. One way to accomplish this protection is to file for a PCT application, which is also known as the Patent Cooperation Treaty. The PCT application is considered a placeholder for your international patent application. It must be filed within 1 year of the earliest priority application date, whether it is a provisional or a non-provisional application. As a side note, however, I would like to describe the differences between a provisional patent application and a non-provisional patent application as follows. A provisional patent application costs less and gives the inventor flexibility to quickly protect an invention, but protection only lasts for 1 year. This basically gives the inventor an opportunity to conduct more research or finish the invention before filing a non-provisional application. A non-provisional patent application, on the contrary, is much more costly and the process takes a very long time. Another way to accomplish foreign patent protection is to file your application with the European Patent Office, also known as the EPO. The EPO is recognized by 36 member states and 2 extension states. Keep in mind, individual countries require their own fees and filing your application with them, and for language translations as well. With regard to your startup endeavors or existing business growth initiatives, you may need to make a decision of whether or not your invention should be patented. So please consider the following. Regarding your budget, can you afford a patent? It is no secret patent registration and patent prosecution can be costly. Decide if you should first file for provisional application, which, as I previously stated, is a lot less. And then after a year, you can consider filing for the non-provisional application, which would be, eventually more costly. Is the invention patentable? For example, is it novel, new, useful, or non-obvious? A patent attorney can help you with this entire process, and I highly recommend that you hire one depending on your goals. Consider if there is a market for your invention and what is the commercially viable life of the invention. That is why I highly recommend research is so important. Does your invention infringe upon another's? You need to find out before you go forward with your own invention. Have a full professional patent search conducted. Research what your competitors are working on. Consider if disclosing the invention to your competitors reveals valuable information you would prefer to keep secret. Do you have trade secrets? This is now a perfect segue into a brief conversation about trade secrets in general. One example of a trade secret I would like you to consider is Dr. John Pemberton, who mixed together sugar syrup and other ingredients in 1886 to make a refreshing new beverage. He basically came up with the secret formula for Coca-Cola. He kept it secret and protected it as a trade secret. So a trade secret is information which A, provides a business with a competitive advantage, and B, is treated in a way that can reasonably be expected to prevent the public or competitors from learning about it without improper acquisition or theft. But in order to protect your trade secrets, you need to know the elements of what constitutes an actual trade secret. And those are, a secret is not known by others. The secret is not readily ascertainable. And reasonable efforts under the circumstances to maintain secrecy have been made. Let's now compare the key differences between trade secrets and patents in general. With regard to public disclosure, a patent is disclosed to the public upon registration, but a trade secret must never be disclosed to the public. Regarding the extension of protection, trade secret law gives you no recourse if someone discovers the information on their own. But patent infringement is the opposite, and you have a remedy to sue the infringer in a court of law. With respect to the length of protection, understand that patents are protected for 20 years, and trade secrets are protected as long as the information remains a secret. And last but not least, regarding registration. Trade secrets do not require registration, but patents definitely need to be registered. Okay, so far I have briefly explained patents and trade secrets. Let's now begin a quick discussion on copyrights. When Ernest Hemingway wrote The Old Man and the Sea in 1952, what he wrote was protected by copyright. Copyright basically protects creative works such as software codes, website content, musical compositions, audio recordings, movies, books, articles, diagrams, and photographs. Copyright protection covers unique expressions of ideas and can be obtained as follows. In the United States, copyright exists upon submission of your work to the U.S. Copyright Office, which is a department of the Library of Congress. No registration is needed. Now, note that the work must be original and that copyright protection provides exclusive rights to the owner, such as reproduce work, prepare derivative works, distribute work to the public, perform work in public, as well as display work in public. The term for an individual owner is 70 years after death. And the term for corporate authorship is 95 years from the publication or 120 years from creation, whichever expires first. So what are the benefits of copyright registration? Although registration is not needed, you must have registration before you can sue another for copyright infringement. I will provide you with a bit more information on how to build a legal case against a copyright infringer in a few moments. You can also claim statutory damages and attorney's fees if your work was registered before infringement or within 3 months after publication. Registration serves as proof the copyright in the work is valid and supports notice of a copyright claim. Registration can also be recorded with the U.S. Customs Service to help prevent importation of infringing goods. Think of top designers of handbags, shoes, and clothing, etc. As I briefly mentioned before, although copyright registration is not needed, you must have registration before you sue another for copyright infringement. Please note, it is not always easy to fight copyright infringement, but it is possible. As a small business owner, your copyrights are important for the continued success of your business. You don't want to see other people using your products or creating copies of your products without being penalized or without getting permission from you directly. In fact, if you are someone who works online, it's a little easier to document suspected copyright infringement and to pursue a claim against someone who has violated your copyright. So here's what you should do to help collect evidence for your legal claim. First, you will need to grab a screenshot of the offending page, product, or material as it is online. Second, you should write down the website's name and download the source code when you're on the page. Third, it is a good idea to see if the website has been saved in archive.org as well. So you know there is always a copy available, to you for others or others. Keep in mind that any screenshot taken has to meet requirements to get used in court. Therefore, you should remember which browser you used to take the screenshot and also take down the version of the browser used. You will then need to include the date you assessed the information. The fourth thing you should do is find out the first date of use. In other words, it is helpful to know when the offending content was used online for the first time. You can check how long the website has been online, along with the date the article or information was published. This gives a court an estimate of how much time your copyright has been infringed upon. So it can help determine how the other party should pay for damages. With regard to the first date of use, information about monetization also helps. When someone makes money off your products, it's more serious than if he or she made no money and caused you no real monetary damages. Do not forget that monetization through ads count, as do sales and other profit-making schemes. So if someone is making money off your content, it's definitely within your legal rights to stop the infringing party. The above are just a few pieces of information and suggestions you'll need to have if you want to take your copyright infringement case to court. Obviously with good evidence, including screenshots, archived information, monetization documentation, and dates of use, you can make a strong case in court and help protect your own interests and copyrights. Remember, a solid case needs to have evidence from a variety of sources, so collect as much information as you can. Now let's move on to international copyright protection, which is likewise as vital to know and consider. Protection against copyright infringement in a particular country depends on the laws of that country. Most countries offer protection to foreign works under certain conditions, which have been greatly simplified by international copyright treaties and conventions. For example, the Berne Convention for the Protection of Literary and Artistic Works has about 100 member countries and provides each member country with recognition of copyrighted works authored by nationals or of other member countries. Okay, thanks for hanging in there so far. I'd like to now begin a segued discussion about trademarks, which I know is of most interest to most business owners at this time. This type of intellectual property regarding trademarks is most common with business owners and essential to understand if you wish to register a trademark logo or domain name. One great example is when George Eastman came up with the name Kodak for his camera in 1883. What he basically came up with was a trademark. As depicted in the example photos provided on your screen, trademarks consist of brand names, logos, slogans, and even product shapes, colors, and sounds. So what is a trademark? Trademarks are typically referred to as brand names, but there are other types of trademarks. Basically, trademarks let consumers know that what they are buying comes from a particular source. They are considered identifiers, which set one company's goods and services apart from those of others. Trademarks describe or represent the name for the product or the service. An example is Google as a search engine or Intel for a microprocessor. A strong trademark is one that has originality and distinctiveness. Generic words are not protectable as trademarks, such as the words car and computer, chair, things like that. The strongest types of trademarks, however, are, quote, unquote, made up words, also known as fanciful words. It can be very challenging choosing a unique trademark, but once you understand what is and is not considered distinctive or unique, will determine if it can or cannot be protected. For example, a generic mark represents the name of a product or service such as car, computer, and financial services. Generic marks are not distinctive or characteristic, and therefore no protection can be obtained. A descriptive mark, however, tells something about a product or service directly, such as premium gasoline, Yellow Book, California Wines, and Lincoln. Descriptive marks are not protectable unless you can show its distinctiveness through advertising and sales. A suggestive mark, however, suggests something about a product or service indirectly, such as Coppertone, Duracell, and Taco Bell, and may or may not be distinctive enough, so protection could be a challenge to obtain. On the other hand, arbitrary marks have no relationship to a product or service, such as Adobe for software, Domino for sugar, and Subway for sandwiches, but are inherently distinctive and can still obtain full protection. Last of all, fanciful marks are made-up words such as Kodak, Exxon, and Xerox, and are inherently distinctive and can get full protection as well. In the United States, trademark rights exist upon actual use, but in other countries, priority is given to a party who has filed for registration first. More importantly, apply for trademark registration in most important countries, and it is recommended, such as the United States, Asia, and Europe. Apply for related domain names before your product or service launches. Note that depending on the country, obtaining registration could take 1.5 to 10 years. Finally, the term of a trademark could be perpetual with continued use. So what are the benefits of federal trademark registration? For starters, you obtain proof of validity of the mark, ownership of the mark, and exclusive right to use the mark in commerce. And there's a statute that specifically indicates that. Filing gives nationwide priority, except against prior use of others. After 5 years of registration, the mark cannot be contested. You have the right to use the R in a circle symbol after the mark, which is registered. Profits, damages, costs, and attorney's fees are recoverable for infringement. Additionally, to help prevent importation of infringing goods, you may record the trademark with the U.S. Customs Service. You can also use as a basis for foreign registration of said mark. And lastly, the trademark is listed in search reports to help give notice to others that it does exist and to deter copying of a confusingly similar mark by others. These are the benefits of federal trademark registration. Trademark protection is generally available only on a country-by-country basis. So just because you registered in one country does not necessarily give you trademark rights in another country. But it is easier to register trademarks in multiple countries thanks to the international conventions and treaties, such as the Berne Convention for the Protection of Industrial Property and the Madrid Protocol. If you recall, I mentioned earlier how small business owners make the mistake of not obtaining proper intellectual property protection, whether it's a patent, trade secret, copyright, or trademark. If you do your due diligence and prepare in advance, you will help to avoid trademark infringement of another's idea and protect your company from unnecessary and expensive litigation. Therefore, it is highly recommended you seek advice of an intellectual property attorney. As an IP attorney, that individual should have the appropriate background for the patent you wish to register. For example, you don't want to hire a patent attorney with a mechanical engineering background to write your patent application for a chemical patent. I think you get my point. So the background should match the appropriate patent application, right? Know who will own trademarks, copyrights, patents, and trade secrets. Each can have a different owner. Understand the different types of intellectual property protection, which qualifies for work product. For example, software may be eligible for copyright, patent, and trade secret protection, and logos may be eligible for trademark, copyright, and design patent protection as well. Some key issues to specifically identify with regard to patents include, but may not be limited to, who owns the invention? Check your employment agreement. Did you agree to assign patent rights to your employer? Because some people are scientists and they work in universities, and so you want to check that, did you check your employment agreements if you are currently working, regardless if you have a business or not. Note that even without a written agreement, your employer may own the invention if you were hired to invent. Think of scientists or researchers at medical universities, for example. Document the entire development process of the invention and ideas. Do not disclose anything that you may later want to patent without filing a patent application or obtaining a non-disclosure agreement, an NDA. It is highly recommended also to file the patent application as soon as you can. Extend the patent application to key foreign markets as well to expand protection. Now, key issues to identify with regard to trade secrets include limit disclosure, share information only with those who have a need to know, implement appropriate safeguards to protect secrecy of information. Do not disclose confidential or proprietary information without having a non-disclosure agreement in place. Most inventors instinctively understand the value of keeping their technology secret because their main concern is that others learning of that technology will beat them to the marketplace. So the proper way of proceeding is to have the person receiving that information sign a non-disclosure agreement that recognizes the inventor's trade secret rights, requires the reviewing party to keep the disclosure in confidence, and not use it without further permission. Such an agreement, also known as an NDA, needs to be properly prepared and signed before the disclosure of the information is made. I would certainly have my IP attorney draft the NDA for best protection. Now, some key issues to identify with regard to copyrights include, who owns the copyrighted work? Did you write it in the course of your employment? If so, your employer may own the work as well. Did an independent contractor create the work for you? If so, the independent contractor may own the work unless you get a written assignment of rights. For important works such as software code and manuscripts, it's highly recommended you seek registration immediately upon publication of same. Lastly, key issues to identify with regard to trademarks include: choose trademarks that are distinctive. Consider applying for trademark registration on an intent to use basis in the United States Patent and Trademark Office as soon as possible to establish priority of that mark. Register domain names as early as possible. Consider filing applications in key foreign markets. Well, we have finally come very close to the end of our IP Basics webinar. I've covered a lot of categories for you to understand that as a business owner or an inventor, it is very important to protect your idea, your creative ideas. And this way you help to, you'll have recourse in a court of law by having proof that you have registered your trademark, for example, before someone else copied it. This is a helpful resource list that I've put together. And at this juncture, what I wanted to do was spend a few moments to digress from the presentation to the uspto.gov website. So give me a moment to switch screens because I wanted to show you how to basically navigate through that site. Okay, so just bear with me a moment. Okay, very good. Priscilla, can you see the screen? Okay, so here we have the uspto.gov site. This is the main page. As you see, there's subcategories. There's patents, and if you click over this, you'll see getting started, patent basics, the process overview, legal assistance and resources, inventor and entrepreneur resources. This is invaluable information for you at your fingertips. Also, under patent application process, there's searching for patents. There's filing online, learning about patent classifications, maintenance fees, all kinds of great information is there for regarding all things patent, okay? But more particularly, most people are interested in trademarks, and that's understandable. You want to protect your brand company name, and you want to protect that logo. So this is a great resource for you to navigate through. There's a trademark questions and answers there. There's the process overview, trademark basics, international, if you recall, I mentioned the Madrid Protocol and international protections. That is there in case you want to protect your trademark, overseas, globally. Then there's the category of application process, searching for trademarks. So let's say if you go here, let's see what happens, right? And you want to search a trademark, you could search our database. You see here, search our trademark database. And if let's see what happens here. Okay, so I clicked on that, and then I wanted to just, I don't know, search for. Let's say it's a basic mark that you wanna look for. And let's say we click there. So right here, you would indicate the mark. So I don't know. Let's say Nike. Let's see what happens with Nike. So you would see here, there's 168 records found, right? These are the registered numbers are here, right? These are the serial numbers assigned to that particular mark. This is the word mark it's associated with. So Nike, you could check the status. Is it live or dead? See here in this column. And that's basically, you know, if you have a particular brand name or a company name that you want to at least do a preliminary research on, do a search for the trademark. Let's go back to, okay. Now, I'm just doing this so that I want to get you familiar with the jargon, the terminology used in intellectual property. Because the more you understand and the more knowledge you obtain, the better you will be able to make informed decisions going forward to protect your creative ideas. You know, a lot of inventors have, a lot of people have wonderful ideas, and the first mistake they do is disclose it to friends and family members, and just, you know, just sharing it with the world, probably putting it on social media. Well, by you discussing your great idea, you've just disclosed and given permission to someone to steal it from you, if you will. So that is not recommended. I always feel that there's a lot of wonderful resources that are free for you to take advantage of, and always, you know, think, plan, and then react to something. You know, your trademarks and your patents, even your copyrights. I'm an author and I have everything copywritten. I've written songs in the past and I have that copywritten. And that's just to protect the idea, the creative side of your business. Okay. Now let me go back here. Okay, if you look here, where is it? There's intellectual property information in New Jersey. You can go, if you go to the uspto.gov, learning and resources, inventors, entrepreneurs, that's a really good resource as well. But one of my favorite resources is the first one. It's the US Patent and Trademark Office's Inventors Assistance Center hotline number. And you can call that number in the event that you are seriously considering filing a trademark, or, you know, maybe filing a provisional patent application, which is a lot less. It's kind of like a placeholder for you for the first 12 months. Now, I want to mention as a caveat that federal law does not mandate that you file for trademark protection. You don't have to. However, the purpose for registering your mark is so that in the event someone steals your idea, you know, you have recourse in a court of law, because the judge is going to want to know who filed for registration protection first. And hopefully you have. So in going forward, if you are looking for free counseling, if you see on the bottom here in red, please sign up at rnsbdc.com. That is where you can get you know, free counseling, and you know, yeah. So on a personal note, I want to mention that I have many years of experience combined in intellectual property law as a patent paralegal. I worked in New York for 20 years with some of the best intellectual property law firms in the world. And I've garnered years of experience in that field. And so I fully appreciate what's involved. As a small business owner, I do, you know, understand that research and due diligence is critical for starting a business, as well as developing and growing the business for the future, but more particularly understanding what decisions you're making and why. Because your intellectual property protection can save you in the long run, maybe perhaps millions of dollars, depending on your creative idea. So be smart about your decisions. Don't be afraid to ask questions. Take advantage of any free resources out there. And, that's basically all I have to say about that. I hope that my information and tips will inspire and help you to consider protecting your great ideas. So let's see. Let's go into some questions. Let's see how this is gonna, let me see, Q&A. Okay. Software development, William, software development, what pattern? What would I need? Okay, that is definitely a question that you should address with either a patent attorney, because software development is it's a relatively new industry. And so I would definitely not look for, how would I look up software code development? Yeah, these are particular questions that I would definitely go on the uspto.gov website, everyone, if you're interested in software coding and development, and how to protect that. And also contact the hotline number that I have shared with you online. I believe it's 1-800-786-9199. Those are agents there that can assist you with that information. I also have a question. Is it expensive to file for federal registration? Well, to file a trademark registration you have to pay $275 per classification. And think of a trademark classification as a particular category. So let's say you have a trademark that you want to protect under the classification of, I don't know, cosmetics and skincare. So that would be $275. But what if you wanted to sell clothing and accessories? So that now that takes you into another completely different category, and that would be another $275. So again, if you go to the uspto.gov, you can look up the fee schedules. That's where you would find all of the necessary fees for everything that would be required. Now, as a side note, if you were interested in saving some money, you can file for a trademark protection in the state of New Jersey, and that's only $50. So that's not too bad. That could be one way to protect yourself, and that fee is $50 per registration, and then it's an additional $50 for each additional classification, if it's applicable to you. And the term of that registration in the state of New Jersey and renewal is 5 years. Okay? 5 years. And it's only a one-page document. Okay, someone here, Erica. Hi, Erica. I am a fashion designer. I have ideas for shoes and bags. I need to know if I should have an NDA drafted before working with the manufacturer. Should the idea be copyrighted before or after the sample is developed? Well, okay, so I would definitely have an NDA drafted and signed by the manufacturer, because you want them to waive their rights to your ideas. So yeah, I would have an NDA drafted, have them look at and sign it, because it's really in your benefit to protect your idea. Now, as far as copywriting, you can submit a whole portfolio or a copy of a portfolio of all of your designs of the shoes and the bags all together for one fee. So yeah, you can also protected under copyright copyright protection as well? That's a very good question. Thank you. Now, someone asked, do I need an attorney and what type of attorney should I hire? Look, I'm not going to lie to you. You know, intellectual property is not mandatory overall, but it is necessary if you really have a very, very special idea and you want to protect it from others copying it and, you know, making money off of your idea. So I would set aside a budget for, you know, an attorney's fees, because they usually have attorneys. When you hire a patent attorney or an intellectual property attorney, you want someone who has experience in both patent and trademark filing, right? They usually will offer you a retainer fee, you know, a contract. So it could be 5,000, it could be 10,000, I don't know. But whatever it is, you want to at least start exploring what kind of budget you would need to allocate for intellectual property protection for your business. Okay, that's also something that you have to consider in going forward, and especially when you're writing and filling out your business plan, your financial projections. If you're someone who is inventing something, an actual product to be manufactured, then yeah, I would definitely speak to an intellectual property attorney. Now, here's another thing I wanted to just as a side note mention that I didn't mention before, and that's licensing. Now, licensing is a whole other animal, but if you file for a patent and you get it, you know, and it's cleared that it's an invention, you are the sole owner or whatever. Well, what happens is, instead of you manufacturing that product yourself in a warehouse, you may want to consider maybe, I don't know, having it licensed the right to your patent idea with a company who already does that. So for example, if you have a toy that you invented that is really like amazing and it's gained super popularity, well, I mean, I don't know about you, but I'm not interested in manufacturing a toy. But if it's going to make me millions, well, then you know what? I will look for maybe approach Mattel or another company that manufactures toys to see if you know, they would be interested in licensing the right to that. You know, Shark Tank is also great too. When you watch that show, there's often a question or an inquiry about, do you have any intellectual property for this idea? Because we like it, but are you protected? And investors like to know that you are, because they don't have to foot the bill for that, because that could be very expensive. So, yeah. Now, there's, let me see, with regard to the resources, again, that I provided for you, where is the other sheet? Let me see, what did I do with that? Okay. Let's see. Oh, here's another question, sorry. Kate, thank you for your question. Copyrights. If I put the copyright symbol at the bottom of my website and state that all information on here is copyrighted, does that count as copyright? Yes, it does. It's what you do is you put the C in the circle, put the years, right? Let's say 2000, so C in the circle, 2020, and then you put the name of the company, period, and then you say all rights reserved. So I'm gonna type in the answer so that you could see what I'm talking about. So the C in the circle, because I don't think I can manufacture that at the moment. C in the circle, put the year, then put your company name, right, period. Then you type in all rights reserved. All rights reserved. Okay. Okay, that sounds okay. Let's see. Now, William says, he's asked me, he lives in Washington, D.C. Can I patent everything in New Jersey, as you suggested, cheaper? Okay. All right, you can't, I'm not talking about, I didn't mention that you can patent. I said you can trademark your mark and logo in the state of New Jersey. Okay? If you're talking about a particular patent, William, it doesn't matter where you live in the United States. You go to the uspto.gov, and that's where you would find the information on how to proceed filing a patent application. Now, I did mention with regard to patents, it is cheaper to file for a provisional patent application. It's just to let the patent office know that you're going to take 12 months in order to make the decision to prepare for a non-provisional patent application, which is much more expensive. And I highly recommend that anyone who's planning, especially for patent protection, to hire a patent attorney in that respective industry and field that you're looking to patent a product and protect. I hope that helped you, William. Now, Baina, let's see, who's this? What do you mean by corporate authorship? Well, if, let's say, like my company, Chefs Global Alliance, if I copyright a book, right? If I wrote a book, which my second book is coming out at the end of the year, and it's a startup guide, but anyway, once I copyright that, I can put that under my company name. Instead of Wendy Oliveris individually, it would be under my company's, protection. So yeah, that's the difference. And are any descriptions to your product service considered copyright worthy? Yeah, anything that you, so let's say you want to, I don't know, do online classes and you have a you have a specialty in a particular area and that's what you're known for, and yet you put together a proprietary program. Well, that product and service, everything that you have listed in that complete program is considered copyright, worthy, absolutely. William asked me, can we hide you? What do you mean, can you hide me? Oh, can we hire you? Oh, okay. That's funny. Talk about a Freudian slip. Well, I represent Rutgers-Newark, so they're my client and they hire me to assist you. So, I mean, if you go online and request for free counseling, and then I can give you further guidance as your counselor, if you need that, William. Okay. You're welcome, Baina. So basically, everyone, I just wanna highlight that when you start a business, there's so many factors involved, so many things to consider. But under that category of legal protections, you have to consider your business insurance, right? You have to consider intellectual property protection so that you avoid, infringement in the future. And, getting corporate advice on a corporate attorney or an intellectual property attorney, it's really important that you take out the time to really do your due diligence, because every decision you make is a reflection on the business. And making smart decisions and having a smart strategy plan in place will help you to establish that foundation that you're going to need in going forward. And actually right now, because of the social distancing and the COVID-19 issues and all that, right now is actually a very good time to consider starting a business, because you have that time on your hands. So oh, Erica, great question. What is an example of something someone would patent in fashion? Someone, perhaps think of, let's say someone in fashion designed a, I don't know, a jacket that has very special pockets for certain things, and they designed it. That would be considered and fall under a design patent, because that idea of the jacket, there's something distinctively different about it, and it's useful for other things than just wearing it. It's fashionable, but it also has other things in it that is different from every other jacket. So yeah, that's an example of what could be patented as a fashion designer, right? Now, trademarks and copyrights, yeah, in fashion is one thing, but patent protection, remember, is it a design? If it's a design patent, then yeah, I would protect it. Kate, thank you. You're welcome. Thank you so much. You're welcome. Erica, unusual patterns would fall under trademarks and copyrights. What I'm talking about is something tangible, something physical. Like think of a stapler, right? You know, a stapler has that part, that mechanism that you lift it up and you insert the staples when you run out, right? Well, in fashion, it depends. Are you inventing an actual product? Right? If you're in the cosmetic field, are you inventing something where the actual brush for the eyelashes would curl them a certain way and it's ergonomic in the handle, all kinds of things like that? That would be considered a design patent. So unusual. I hope that answers your question, Erica. Got it. Very good. Erica, why don't you also consider, all of you should consider the free counseling opportunities that we offer you. We're here for you. All of our counselors have expertise in all areas. So let us help you. Any other questions? Before we end, I know I've covered a lot, but you're very welcome, Erica, and have your portfolio ready. Yeah, you can copyright it first and then save some money to talk to an attorney and hire that attorney. Attorneys, that's what they specialize in. Intellectual property attorneys only focus on your best interest and how to best protect your idea. And licensing is a great, feature. It's a great thing to do because you get royalties. You'll get royalty checks, for your idea. So yeah. So without further ado, if you don't have any other questions, I think you all are well informed today. I hope you've learned many things regarding intellectual property protection. And I always advise everyone or anyone who's thinking about starting a business, you know, do your due diligence and research. Now, Kate, Kate is asking, what is the proper process for using bits of copyrighted information on your social media? Do I just have to cite the author's source? Yeah, you should do that. Yes, and in many occasions, you're going to have to ask for permission from the author as well. So you want to be careful with that. So, so for example, I have my blog that I write articles that I personally have written. And if I went on your website, Kate, and I look on your blog and I see that you copied my blog without giving me my credit or without even asking me for permission, yeah, I might give you a call, or I might have my attorney contact you and ask you to, you know, a cease and desist letter to remove that from your site because you were not given permission. It all depends, you know, everything is relative. But that's why on your websites, always put that C in the circle, and in anything that you write, you know, to protect yourself. And again, I refer you back to the uspto.gov website. It is a wonderful, very user-friendly site. It's broken down into, you know, the patent, trademark, and copyright categories. And all of those inquiries could be easily, you know, reviewed there as well. Because I'm not an attorney, but I am very familiar with this industry. And as a successful small business consultant, I always help to build a strategy for my individual client so that, you know, they protect themselves in all areas, legally and you know, cost effectively. Well, your trade secret is protected by you, number one, Shukurat, by you not disclosing the trade secret. You don't disclose it. You would need to have non-disclosure agreements with anyone in your company so that they don't go out and, you know, give out your secret sauce, if you will. So let's say you have a secret sauce and you don't want that disclosed, you know, you have those non-disclosure agreements drawn. And you don't, trade secrets are protected, you know, by copywriting, perhaps, you know, well, like I said, I would definitely speak to a patent attorney about that, or a corporate attorney, because your trade secrets should not be disclosed if it's the source of your business. And protecting it means not disclosing it to the public. Okay. Let's see if anyone else has let me see something. Let's see, let me drop down. And wow, we've covered a lot of ground today, everyone. Your questions are all wonderful. I see someone's paying attention. Any other questions before we sign off?
I think that's it for questions. I'm not seeing any more.
Okay. Okay. Well, once again, I'd like to thank everyone for attending our webinar. It was certainly a pleasure being with all of you today. Your questions were excellent. Please feel free to contact me directly or through the, you know, rnsbdc.com and get free counseling. Very important. Take advantage of that. And I want to wish you all the very best in your future business endeavors, your startups. Keep dreaming big. Just don't forget to protect your amazing ideas and stay safe and healthy, and God bless. Thank you.